We'll get right into it. So, who is Texas Legal? We're a nonprofit that was founded in 1972. We were created and endorsed by the State Bar of Texas in order to help other Texans out. We have an extensive attorney network and the most comprehensive plan on the market. We're also a local provider of superior service. So the problem is that a lot of people need legal help, but not everybody can afford it. Legal issues are common. In the last 2 years, about 66% of people have experienced at least one legal issue. However, legal help is also very expensive. On average, an attorney can charge you about $280 an hour. And for the middle class, that can either be out of reach or a financial disaster. So that's where Texas Legal steps in. We're similar to your health insurance, except within our network, we're going to have attorneys instead of doctors. There's no copays or deductibles. You're able to choose your own participating attorney, and then that attorney would bill Texas Legal directly for any covered legal services. Our legal network does offer a wide selection of attorneys in every area of the law. We have over 400 attorneys statewide. The average experience is over 20 years, and they're all licensed in the state of Texas. If you don't have an attorney in your area, you're also welcome to use the out-of-network benefit. We offer protection and peace of mind for every stage of life, from things like divorce, custody, bankruptcy, DUIs, writing a will, or even identity theft. Our most popular benefit and the greatest gift that you can give your loved ones is the estate planning benefit. Texas Legal does pay for the attorney's billable hourly time on your behalf. This will include a simple will or up to 8 hours for a will with a living trust, 2 powers of attorney, 1 living will, 3 additional documents. This is some of the details of the 2 plans that we offer, the Select and the Preferred plan, and the costs are located right below that. The Select plan does cover your estate planning. Most other benefits have a 25% discount. However, the Preferred plan, it does cost a little bit more, but it covers everything from estate planning, family law, which may or may not include name change, adoption, pre or postnuptial agreements, divorce or modification or establishments of orders, things like civil law, so consumer protection and defense of civil action, criminal law for things such as misdemeanor, felony, driving under the influence, traffic tickets, and even real estate and financial transactions like bankruptcy, residential real estate transactions, and identity theft and monitoring and repair. So how do you sign up if you're a Texas Public Employees Association member? You can actually enroll at any time by visiting texaslegal.org. When asked how the plan is made available to you, you would select my group. It would be Group 2 and then list Texas Public Employees Association as your group name. Once you enroll, you do receive your welcome kit by mail within 2 weeks of enrollment. The cutoff for enrollment is the 25th of each month. So since we are the 29th, your application would not be effective until June the 1st. So I want to go over some of our most frequently asked questions. First and foremost, once I'm a member, how do I find a participating attorney? It's very easy. You're welcome to give us a call at our member services line or visit our website, texaslegal.org. On the top right-hand corner, there's a link called Attorney Finder. From there, you'll enter the criteria such as the type of attorney you wish to find and the area that you want to work with when in. When you reach out to the attorneys, you do need to let them know that you're a Texas Legal member and they will request your subscriber ID. So when can I use the plan? Everyone is effective on the 1st of the month and all benefits are available as of your effective date other than bankruptcy. Bankruptcy has a 3-month waiting period from your effective date, and the divorce, modification, or enforcement or establishment has a 6-month waiting period from your effective date. Both of those are only going to be available to the named participant, and pre-existing matters are not going to be covered, meaning anything that's already happened or been filed with a court. However, they are eligible for a 25% discount. So does my spouse need to be on the policy to have their will drafted? Absolutely. Just like any other insurance, if they're not on your policy, they cannot use the benefit. We have a joint estate planning benefit for married couples. So if you wanted to get your estate planning done, we do suggest that you schedule that meeting together and both go meet the attorney at once. So can I add my parents to the policy? Unfortunately, no. The family policy is considered to be yourself, your spouse, and any dependent children or stepchildren up to the age of 26. However, Texas Legal is available to the public, so anyone is available to purchase the independent policy. What fees am I responsible for as a member? You do have to pay the attorney for things such as incidental cost. This may or may not include copying, faxing, postage, notarization, filing fees, court costs, but we do suggest that you ask your attorney whenever you're meeting with them. So how often can I use the plan? Each benefit is available to you once per plan year. The plan year runs September through August, so every September your benefits will renew. Everyone on the policy, if you're on the family policy, is sharing all the benefits. So if someone were to use the speeding ticket benefit, it would not be available again until the next September. So can I keep this plan if I retire? Absolutely. The plan is portable, so if you're no longer with TPEA and are a retiree, you can continue to stay on the TPEA plan, or you can convert to the independent policy if you wish to do so. With that, I also wanted to show you the utilization report for the usage of the last year for TPEA members. We had a total of 224 members enrolled and paid over 10,000 in claims in 2001. This covered things like estate planning, consultation, probate, consumer protection, preventative legal services, and even bankruptcy.
Anna, may I add one clarifying point?
Yes, of course.
We have a lot of TPA members that are retirees, and they can still stay on the TPA sponsored Texas.
Absolutely, because this is an association. As long as they are with TPEA, they can continue to do so even after being members with TPEA.
Thank you.
Of course. With that, I do want to thank everybody for your time, and I'll turn it over to our participating attorney, Andrew Gore.
Well, thank you, Anna. I appreciate that. And thank you for all that information. Let me share my screen here real quick to have the presentation for us. All righty. Well, again, I appreciate Texas Legal and the Texas Public Employees Association for giving me this opportunity to come and speak at this webinar. I really appreciate everyone that's out there listening and that you've carved out some time in your schedule to come and listen to me present and talk about something that I'm really passionate about, estate planning and probate. I really do consider it a privilege and honor to speak with you. And hopefully there'll be a nugget or two of new information that I can give you that will be beneficial. The plan is, I did a dry run of this presentation yesterday. It's about 25 to 30 minutes. And there's going to be some time at the end for some questions. So feel free to put those questions in the chat or the Q&A section there in the webinar. We also received some questions ahead of time that hopefully we can go through as well. I do want to say this, we're probably not going to be able to get to all the questions. And there may be questions that are very detailed and very specific to your family or your assets and your goals. And so, but I want to answer those questions. And so here's my contact information. Here's my email address. Here's my telephone number. If I don't answer your question, I really want to make sure that it gets answered. And so feel free, don't be shy, shoot me an email and we can set up a call and I can, ask you some follow-up questions and get kind of into the weeds a little bit. A quick aside about Texas Legal. So I've been an attorney for about 12 years now, been a participating attorney through their service for about 7 years. And I highly recommend them. They really are sort of the gold standard for these types of services. So a little bit about myself. I am a probate and estate planning attorney. My main office is in the DFW area over in Richardson, but I help clients throughout the state of Texas. And again, mainly my practice area as far as legal matters go is probate and estate planning. However, when I say estate planning, that term is somewhat misleading. There's this implication that estate equals wealth. And that's really not the case. Your estate is whatever you own, the property and assets that you own. And that could be the clothes on your back or $100 billion. Both of those things are estates. Now, most of us are somewhere in the middle, but ultimately we all have an estate. So as any good attorney, I try to be precise with my words. And so if estate planning is kind of confusing, or maybe there's implications that are not really true, I want to be more precise. And so this may be a little bit blunt, but what I really do as far as this planning is that I help individuals, clients with death planning and disability planning. So I hate to be the bearer of bad news, but you are going to die. Welcome to the webinar. At some point, more likely than not, you are going to be in a situation where you need a trusted person to make a decision for you because you're unable to make those decisions. So stated a little different way, I use legal tools. And as an attorney, we don't have a saw or a hammer or nails. Our tools are documents, they're words. And so I use my legal tools, wills, trust, powers of attorney, to express your wishes when at some later date you are unable to vocalize your wishes because of a death or disability. One caveat with my presentation or our talk today, I will be discussing really high-level topics, really painting in very broad strokes, and frankly, just scratching the surface with some of these topics. Your plan needs to be narrowly tailored to your assets, your family, and your goals. And I may be a little biased here, but I don't think an online form gets you there. So let's first talk about death planning and some of maybe the reasons and consequences of waiting to do this type of planning. I believe for most people, we know that we need to do this type of planning, but it's kind of like going to the dentist or getting life insurance. We know we need it, we just don't want to do it. Maybe there's even a stigma with it. We don't necessarily want to talk about it, right? We just kind of bury our head in the sand. So we wait. We put it on the back burner. Or we wait for some type of motivating event that sort of is going to push us to get these documents done. And as I've been practicing law, there's been all types of motivating things that have brought people into my office. Some of that can be a marriage. Sometimes it's kids. Hey, now we're responsible for this other human being. Maybe we need to get our affairs in order. Maybe someone went through a divorce and they want to make sure that their ex-spouse doesn't have any sort of control over the inheritance. Maybe we're about to retire, and this is another box that we need to check is when we think about retiring. Maybe you've experienced a death in the family and you experience maybe the consequences of that a family member not having this type of planning. Or maybe on the other end, your family member or your loved one that passed away, they did have this all squared away, and now you want to do that. This next one's a little funny. For whatever reason, a lot of people want to get their estate planning in order because they have some sort of trip or vacation, or marking things off the list for the vacation, beach towel, swimsuit, and now will. We need to make sure we do that before we leave. And whatever gets you to my office, that's fine. But it is kind of a little funny to me that that's the motivating factor. And then finally, these last couple of years, we can add global pandemic to that list. That was sort of the motivating factor. But here's the problem as far as waiting, is that first, just to be frank, we don't know when we're going to need these documents. We don't know when we're going to pass away, and we don't know when we're going to be in a situation where we need a trusted individual to make decisions for us. And then what sometimes happens is that there's this 11th hour, or what I call panic planning. And the reality is sometimes it's too late to do this type of planning. When a person signs these legal documents, they must understand what they're signing. And at some point, you're going to lose the capacity to sign them. Just had a situation here recently. Someone called the office. It was a daughter. She was calling because she wanted to get a will done for her mother and a power of attorney. And as I asked some more questions, I learned that, well, her mother is in a nursing facility and is in late stage dementia. And after getting a little bit more of the facts of what's going on, I had to tell her, we can't help. It's too late. And so we just can't do that planning at that moment. And then in other situations, maybe it's a little bit of a gray line, we're not sure, maybe they can. Maybe there's a family member that pulls off a form off the internet and we get it done. Well, the reality is those documents that are done at the 11th hour are highly exposed to attack and contest. And also just the reality of doing things sort of last minute, there can be mistakes, whether you have an attorney or not. And so, if there's a will that's done on April 25th and on April 27th, that individual passed away, that's going to be a big red flag for the court. And so I guess the takeaway here is to not wait. And so what would be the consequences of waiting too long or doing nothing? And again, we're talking about situations of death planning. The legal term of dying without any type of planning is called intestate. When you die intestate, Texas law is going to determine everything. They're going to give you default rules on what's going to happen. And so Texas law is going to determine who gets your property and assets when you die. We call them heirs. Texas law is going to determine how they get the inheritance. And typically that's going to be in a very inefficient manner. Texas law is also going to determine who has priority in administering your estate. And Texas law will also determine who will be the guardian of your minor children if you have minor children. And look, I'm a diehard Texan, but I don't want the state of Texas determining these things for me. I want to put something legal in writing that says these are my wishes. And here's the thing about default rules. So if you don't do your planning and Texas law has to determine what's going to happen in these scenarios, well, they're going to have to think sort of broadly, right? So in most situations, okay, if this happens, well, this is going to be the outcome. Well, that can be okay for some individuals, but for others, it's not. And so let me give you one scenario where it is sometimes surprising the default rules. So question, does every surviving spouse receive everything that the deceased spouse owned? So, and the answer is really no. And the key thing here, does every surviving spouse automatically receive everything the deceased spouse owned? So again, husband, wife, husband dies, does wife receive all of the property? Well, maybe not. If the deceased spouse had children from a prior relationship, then the surviving spouse would not receive everything. The inheritance would be shared with the children from the prior relationship and the surviving spouse. So going back to that scenario, husband and wife, husband passes away, but the husband has children from a prior relationship. Well, his kids from a prior relationship and the surviving spouse will share in the inheritance. And that may not be what the husband wanted in that situation. And there are other scenarios where, again, the default rules really don't get you there. So ultimately, okay, if we don't do those documents, that's what can happen. Well, when you do these legal documents, when we're talking about death planning, what do they provide you? What are you getting in return? Well, high level, you're getting two things. You're getting an assurance that the correct individuals are going to receive the inheritance. And additionally, they're going to receive the inheritance in an efficient manner. So even if the Texas default rules, the property goes to the right person, there's a high likelihood that the property and assets are going to be transferred to that beneficiary in an efficient manner, especially compared to individuals that have their planning in order. All right, so what are the legal tools available to us when we talk about death planning? The first thing that I want to talk about are beneficiary designations. Now, beneficiary designations, that is not a document that I'm going to draft in my office and that you're going to sign. These are actually going to be documents that you get from the life insurance company or the financial institution, and you're going to fill out those forms either with guidance from an attorney or outside the guide. Typically it's going to be with an attorney, but it's not something that necessarily an attorney is going to be drafting. And so with beneficiary designations with life insurance, you name a beneficiary on your life insurance, and then upon your death, that beneficiary only needs to show a death certificate to the life insurance company, and those life insurance proceeds will automatically then go to the named beneficiary. With financial accounts, there's some terminology here that I think is important to understand. If we're talking about banking accounts, so checking, savings, even CDs, they use the terminology payable on death beneficiary. If we're talking about retirement accounts or investment accounts, the terminology is transfer on death beneficiary. They're both beneficiary designations. It's just a little bit more specific to the account. Again, on these, whoever is named as a beneficiary on these accounts, that person will receive the account outright. And the only thing that the beneficiary needs to give the financial institution is a death certificate, and those accounts will then automatically be given to the named beneficiary. And here's one high-level thing that I think is really important to understand in this planning, and as you're sort of thinking about how to implement your plan, is that whatever you have in your beneficiary form trumps what you have in your other legal documents. So an example, if you name your brother as the beneficiary of your IRA, but in your will, you have it equally divided between all your siblings, well, your brother is going to get 100% of the IRA. So as you can see, most people's wealth is in their estate, if you will, is in these assets. And so it's very important that we make sure that the beneficiary designations reflect your wishes regarding death planning. Another legal tool available to us are wills. We'll talk a little bit more about wills and trusts here in a second, but just as a quick thing here, with the will, you are going to need to nominate an executor to be in charge of implementing the terms of your will. There's also trust, another legal tool available to us. There's all different types of trust. There's revocable, irrevocable, trusts that are actually inside of your will. We call them testamentary trusts. High level though, when we think about trusts and whether it's a good fit in your goals, is that trusts allow a level of control after you die. And so when I'm talking with a client and they start telling me their goals, and one of the things, sort of a tone there, is that they want to have a level of control over the assets after they die, well, then we're probably going to gravitate towards a trust. The easiest example is to think about maybe a minor child or an adult child, maybe 18, 19, 20. We don't, minors can't own property, and then also an 18-year-old probably doesn't need to have a large sum of money as well. And so what we do is we put that money in a trust for their benefit, but they don't have access to it until a certain age later on down the line, let's say 25, 30. And so again, one of the main, benefits of a trust is that it allows you to control the inheritance after you die. There will need to be a trustee appointed to the trust, very similar to an executor. That trustee will be in charge of implementing the terms of the trust. And I'll say this briefly here. I think there were some questions that we may answer at the end, but I'm going to briefly talk about these unique deeds that also are legal tools available to us. And they're called revocable transfer on death deeds and ladybird deeds. There's two main reasons that we would want to do these documents. One is, and if we went again, kind of distill it down kind of in simplest form, a revocable transfer on death deed and a ladybird deed what they do is they essentially put a beneficiary designation. We talked about those up here. Essentially, it puts a beneficiary designation on your house so that the named beneficiary on that deed receives the house outright. The other reason that we utilize these deeds is for Medicaid planning. There's something called a MERP claim that can be put on an estate if the deceased person received Medicaid for nursing home care. And so we use these in order to essentially circumvent the MERP claim so that the beneficiaries can receive the homestead without that MERP claim attaching to it. So, we're still talking about death planning, legal tools, wills versus trust. So when I'm having a consultation with a client, one of the things that we have to decide is, all right, is a will or a trust going to be the main legal tool that we use in order to accomplish the client's goals? But before we get into all the weeds of it, I think it's really important to understand that either document can be used to accomplish a client's goals. A will is not necessarily better than a trust, just objectively. It depends on, again, your family, your assets, and your goals. So when should you consider a trust? What are some circumstances that we need to think about a trust? And here's a kind of a list of things of when you should consider a trust. So if you have minor or young adult children, we talked about that just a second ago. A trust is really a good vehicle to, again, provide for the children, but for them not to have complete access or autonomy over that inheritance. There's a trustee there as someone that will essentially accountability person, making sure that the trust assets are used appropriately. And then at some point later on down the line, whenever we think that your children are going to be responsible with their money, then they'll receive it outright and outside of the control of the trust. If you have family dynamics of, his, her, and our children, if there's a remarried situation and there's children from either side and y'all have your own children or some combination of those things, a trust is a really good legal tool because what it allows us to do is provide for all those individuals. And without the trust, it would really just be really impossible to do that. If you have real estate in different states, you really need to consider a trust. Let's say you have your homestead here in Texas, and then you have a vacation home in Florida. Well, you want to have a trust because the trust is a centralized administration of the estate. If you didn't have a trust, there would have to be a probate proceeding in Texas and Florida. And so what we do is we essentially take those two real estate assets and put them as a centralized location with the trust, and makes it very easy for your loved ones there. We also use a trust for tax planning for high net worth individuals. This isn't an issue that we have to address much now because the estate tax exemption is so high, and Texas doesn't have an inheritance tax. And so we don't necessarily have to do much of this planning, but if that's something that we need to talk about, trust is the way that we accomplish sort of the tax planning element. Medicaid planning is also, I guess a trust can be used for Medicaid planning as well, and it's regarding nursing home care. And so with Medicaid, Medicaid is asset and income, there are caps there. If you make too much, if you have too many assets, or if you have too much income, then you're not going to qualify for Medicaid. And so what we can do is utilize trust in order to get you under those caps. If you have a special needs child or adult, you really need to think about a trust. Typically, a special needs individual is going to be on some type of government assistance. If they were to receive an inheritance, that inheritance could affect and they can lose that government assistance. And so what we do is we do what's called a special needs trust. With the special needs trust, the special needs individual will be able to keep their government assistance and also have access to the inheritance for their benefit. They don't lose their government assistance just because they got an inheritance. If you have privacy concerns, trusts are private it's a private document. There's no public record of a trust. And then ultimately, if you want to avoid probate, trust is a way to do that. And we'll talk about that here a little bit more, I believe, on the next slide. So again, death planning, legal tools, wills versus trusts. So let's talk a little bit about probate and how wills and trusts work into that situation. So again, another sort of high level topic that I think is really important. We talked about the beneficiary designations, and those beneficiary designations trump whatever you have in your will or trust. Here's another thing, I guess, topic or thing to understand high level when we're talking about wills versus trusts. So when you come into my office and you sign your will, it is a valid document. However, it's dormant, it's sleeping. The legal terminology is that it's not enforceable. In order for it to be activated and for it to be enforceable, the will has to go through this legal process called probate. Now, probate happens when the person that wrote the will dies, and typically the executor is then going to go through the probate process with the will. But it's only through the probate process in which the will is activated, and then you can use the terms of the will. Now, that's compared to a trust. When a client comes into my office and they sign a trust document, typically going to be a revocable living trust, it's activated upon signing. It avoids probate. It does not have to go through probate in order to be used. Essentially, what we've done with trusts is that we've taken the legal process of probate, privatized it, and baked it into the trust so that there's an orderly transfer of property from a deceased person to the rightful beneficiaries. And just to kind of drive this home, if you have a will and you come to me and your loved one has passed away, and you show me the will, well, you can't do anything with the will. If you go to the bank and show the will and it's not probated, you can't do anything with the will, all right? So just understand, a trust will avoid probate. And again, not every estate has to avoid probate, but if ultimately we decide that that's the case, then the trust is the mechanism in which we do that. We can also avoid probate by doing beneficiary designations and potentially doing those unique deeds, the revocable transfer on death deed. So switching gears a little bit. So we talked about death planning. So now let's talk about disability planning. So disability planning is going to be more sort of the powers of attorney. So what are the consequences of not doing any type of planning when we're talking about disability planning? So the main thing is there's going to be no protection or guidance on how to handle your financial or medical decisions when you're in a situation where you cannot make those decisions. People are in the dark. We don't know what you would want to do in these types of situations. And there's no one in charge to handle these things. And in a worst case scenario situation, there's no planning. We may have to do a guardianship. And you really want to avoid a guardianship. Guardianship is a huge loss of control over a person's life. It's an intrusion by the court system. It's a huge loss of privacy, and it's one of the more expensive things that probate attorneys do. It's very expensive, and so ultimately you don't want to do guardianship. Have these documents in place so that you can avoid that potential consequence of not doing this type of planning. So what are the legal tools available to us for disability planning? These are the documents here, and we'll talk a little bit more in depth here in the next couple of slides of what these documents actually do. But you'll see the first four more sort of on a medical side, and the last one is more for financial matters. The key thing to understand with disability planning documents is they can only be used during your lifetime. So the documents that are these 5 documents here, the powers of attorney and HIPAA release and the advanced directive, they can only be used during your lifetime. They cannot be used when you pass away. So an example would be your agent under a financial power of attorney would not have access to your accounts after you pass away. Their authority is gone at that point when you pass away. What then happens is then we transition over to the documents that we've previously talked about, your will and your trust. On the disability planning documents, let's first talk about the medical documents. The first one, pretty straightforward, is your medical power of attorney. This is the person who's going to make medical decisions for you if you are unable. It's best practice to have a primary and an alternate as well if the first person is unavailable. We also have a HIPAA release. This is the individual or individuals who will have access to your medical records in order to make medical decisions for you. Now, typically with a medical power of attorney, we're going to have, option 1, option 2, option 3, and they serve in succession, meaning that the first person is going to make the decisions. If they're unavailable or if they predeceased, then it goes down to the second person and then so on. But typically I'll say for some situations, yes, we have that succession. These are the decision makers, but we want all of the individuals that are named in the medical power of attorney to have access to the medical records to be able to understand what's going on. There's also an advanced directive. This is also known as a living will. This expresses your wishes regarding life support at end-of-life situations. So if you've been diagnosed with a terminal or irreversible condition and would not survive without life support, you can sign a document which expresses your wishes that you do or don't want to be put on life support. What you're really doing is taking that decision out of the hands of your medical power of attorney and telling your medical power of attorney, physicians, family, anyone else that needs to know, this is your wishes regarding life support. There's also a medical power of attorney for minor children. So this handles the situation if parents are unavailable or can't make a medical decision for their kids. There's people named to make these decisions for your minor children. This document is really important if, let's say, parents are going on a vacation without the kids and grandparents are going to be taking care of the grandkids. Those grandparents need to have a limited medical power of attorney for the time that the parents are gone. So if something was to happen, they need to go to the emergency room or anything along those lines, they would be able to make those decisions. Regarding disability planning, and the financial document that you need for this type of planning is called a durable power of attorney. I like to think of this as your financial power of attorney. Think banking transactions. And so again, this would be a document that is used if you're unable to make financial decisions for yourself. One thing I want to talk about, I guess a legal tool that some people use that is okay in some scenarios, but I always want to let clients know what the legal ramifications are by doing it. So a lot of times what people do is, let me give you an example. So let's say there's mom, and mom wants to make sure that there's someone available to make financial transactions for her if she's unable. So what she does is she puts her daughter on the account. So what's the legal ramifications of putting daughter on the account? Well, that daughter is a joint owner of the account. And so we need to understand what the legal ramifications of being a joint owner is. When that daughter becomes a joint owner, at that moment, she has 100% access to the account and can really take all of it, take everything that's in the account. She has the right to do that. She has the legal right to do it. Second, if the daughter was to ever get into any type of financial trouble, let's say she gets sued and there's a judgment or she files bankruptcy, that account is going to be potentially subject to her creditors or pulled into the bankruptcy court. And finally, when daughter is put as a joint owner, if mom was to pass away, the daughter, the joint owner, would become 100% owner of the account. Doesn't matter what the beneficiary designations are. It doesn't matter what's in the will of the trust. Daughter is 100% owner of the account. Let's say that there was daughter and son. And let's say mother that passed away, she wanted everything equally divided between her kids. Now, sister could maybe do the right thing and give it to her brother, but she's under no legal compulsion to do that. She is 100% owner of the account in that situation. So what's a better tool? Well, the better tool would be to name the daughter as the agent under the financial power of attorney. That would give her the right to access the account, to pay bills, do the things that need to happen if mom is unable to make banking transactions or do any type of financial transaction, but it does not make her an owner. So there's an important legal distinction between agent under a financial power of attorney and a joint owner of the account. And individuals and clients need to understand the difference between the two of them. This is a miscellaneous document that we prepare sometimes for clients. I really wish there was a better name for it. It's what the legislature gave us. It's an agent to dispose of remains. This document, you can express your wishes regarding cremation or burial. You can also decide who's going to oversee the funeral arrangements. And final thing here, I've had a lot of clients come into my office here recently who their family members have pre-planned and actually prepaid for their funeral through a funeral home. And those clients that have come into me have just stated how much of a blessing that was to have. All the decisions have been made, you know, in a situation where typically it's their parents have died. There's they're mourning, they're having to, call family members and those types of things. If everything was sort of squared away ahead of time, it was such a relief to them. And so I know there's a little bit of maybe a stigma with that, and maybe there's some uncomfortableness in sort of pre-planning that. But again, I've had many clients just say how happy they were that their loved ones did that. So final thing here, and then we'll have some questions, is that I do want to talk about the importance of updating and reviewing estate planning documents. So you have the documents, okay, now what? Well, I think the default is you should really update and potentially review the documents every 3 years. We may not need to update them, but we really need to take a look at them, make sure they're in line with, again, your family, your assets, and your goals. If you have any type of major life event, a death, divorce, birth, we really need to take a look at these documents again and see, we're probably going to need to update them because of that. And then if you have any sort of, major new assets, we may need to consider updating your estate planning documents. Let's say you opened a business or you decided to dabble in real estate and have an investment home. Well, how does that fit into, what you did 5, 10 years ago? And so it's really important not only to have these documents, but to review them and update them as needed. The other thing is when I talk to clients about this, one thing that you need to know is you need to know where your documents are. Sometimes they get lost. And especially with the will, we want to make sure that we have the original. Because if you ultimately have to go to probate, you're going to need the original will to do that. We can probate a copy of the will, but there's some legal hurdles that we have to go through in order to do that. And so the other thing when you're sort of thinking about updating and reviewing, okay, do I have the original? Do I have all these documents? Well, that concludes my presentation. Like I said, I know we're going to hopefully answer some questions that were put into the chat and also that were sent ahead of time. But again, please hear me that if I did not answer your question, please email me, set up a call my office. Just let them know that you are part of this webinar, and we'll get you guys set up. So.
Thank you, Andrew. I'm going to go over some of the questions that we received via email. First, want to go over some of the more high-level ones, and then we'll get into the nitty-gritty if we're able to do so. But like Andrew said, if for some reason we're not able to go over the question that you asked, please don't hesitate to reach out, and we'll get those answered to the best of our ability. So I'll get started. I have this question. Is it better to have a will or a trust? I'm single with no children.
That's a great question. And so I'm going to give a very lawyer answer, but it kind of depends, right? There's kind of depends on your assets and your goals and your family. And so, I think what you need to think about when, should I have a will or a trust is that kind of go through those things that I was talking about, and about, okay, should I consider a trust? And if you check one of those boxes, well, then maybe we need to do that. But I'll say this, it may be a situation where good beneficiary designations, a revocable transfer on death deed, and a good will is going to get you there. So.
Thank you, Andrew. So typically, in what circumstances is it more beneficial to name a trust as a beneficiary instead of individuals?
So I'll say this. So kind of an aside here is that if we ultimately decide to do a trust, one of the ways in which we are going to implement your plan with a trust is that we're going to utilize beneficiary designations to get the financial assets and the life insurance into the trust. And so for instance, let me give you for an example, is that, if you have minor children or those young adult children, we don't want to name them as beneficiaries because we don't want them to have it outright. So, if you name them as a beneficiary, they have it, they can do whatever they want with it. If they wanted to go the next day and get season tickets to the Cowboys, they could. But if we want to have a level of control over those assets post-death, then we're going to name the trust as a beneficiary. And so if with your plan is that we want to utilize the trust, we want to make sure that we fund it correctly. We use those beneficiary designations as a way to do that. One other just small thing that just came to my mind is that if you want your retirement accounts to go to your spouse, just name your spouse. And again, if there's not going to be a level of control because there's some advantages, and I won't get into all the weeds of it, it's kind of some tax issues, but go ahead and name your spouse as a beneficiary. So.
Thank you. So I want to be able to leave my home and property to my loved one in a way that would allow them to seamlessly continue living in the home. Use the money I leave to pay the monthly bills, property taxes, repairs, and maintenance. Does a trust accommodate this?
I think it would. There's definitely a couple of follow-up questions to that I would want to know. And sort of, next question would be, okay, after that loved one passed away, what's going to happen to the property? Do we want it to go to somebody else? Because in that question, there's a little bit of, I guess the tone somewhat is having a level of control over it, right? And so if there's anything where we want to have a level of control over the assets post-death, then our bent is going to be towards, okay, let's think about the trust in that situation.
Okay, thank you. So if a financial account such as bank accounts, CDs, 401ks, life insurance policies, etc., show beneficiaries are payable on death instructions, is it necessary to probate those accounts? And what is the minimum value which requires probate? And then there's a follow-up question, but I'll let you answer that first part.
Okay. No, this is a good question. And I can finally give an answer that it depends. So if there's named beneficiaries on those accounts, so I have it here. So bank accounts, CDs, 401ks, life insurance policies, all that. If there's a beneficiary designation, there's no probate. And so the only thing that the named beneficiary needs to do is get a death certificate to those financial institutions. And then, it kind of goes through their process that they have, but ultimately then it is then given to the beneficiary without the need for probate. And then as far as I think you said the minimum value for probate, is there some sort of threshold? There's not. Anybody can utilize the probate courts in this, obviously in this type of situation. There are certain tools with probate court that have some, minimums and maximums just an aside, there's something called a small estate affidavit that when someone dies without a will, we can utilize. It's typically when there's a bank account somewhere that there's no beneficiary, no will, and we utilize a small estate affidavit if the estate is under a certain threshold. So I guess amounts sometimes come in, but there's no sort of minimum that requires probate. And let me also say this, kind of a thing to think about with probate. Does every will have to be probated? No. There's no legal requirement that a will has to be probated. Probate is a need-based system. You go to probate court if you need to go, right? And so I think there's a follow-up question to that.
Yeah, it asks, do the personal belongings need to be probated if a trust designates that they either be divided or sold at the discretion of the trustee?
Typically, no. With those personal property things, if there is any type of conflict, we'd have to maybe get the judge involved, but I've never had a situation like that. Typically, the beneficiaries are able to handle that. And with a trust, one of the things that we do is, from a legal standpoint, we transfer all the personal property to the control of the trust. There's no like bill of sale or any sort of transfer. There's a transfer document, but ultimately, when that person passes away, those personal property belongings will be under the authority of the trust. And again, typically family members are going to, defer to that. I will say this, if there's a particular asset that you want to go to a particular person, maybe there's some type of sentimental thing. Maybe it doesn't have a lot of monetary value, but it's very sentimental and you want to make sure it goes to that particular person. It's best practice to specifically name that asset to that person. We call it a specific bequest or a specific distribution in the documents. And with that, then it's more legally binding. It has a little bit more teeth to it.
Got it. Thank you. So someone wanted to hear your comments on the Texas transfer on death deed.
Sure. And we talked, there was a little bit in the presentation with that. And so let me talk really high level here. Again, each person's a little bit different in their planning. And so I guess the first thing to understand is that these transfer on death deeds, they are a relatively new legal tool. I think it's been about 5 or 6 years that they've been on the books. And so anytime there's something new, it really hasn't worked through the court system and those types of things. There's a little bit of a hesitancy, just, you don't want to be the guinea pig, right? You don't want to be that one case, right? So we just need to kind of talk about that a little bit. And it doesn't necessarily always fit in every situation. I guess let me backtrack a little bit, is that if you remember in the presentation, what a transfer on death deed does is that it essentially names a beneficiary on your house. So just like the life insurance and the financial accounts, you name a beneficiary on those accounts, get a death certificate, and those things are automatically given to the beneficiary. Well, okay, it's with a revocable transfer on death deed, that's what we're doing with the house. It would avoid probate. If you do the transfer on death deed, it's in the county records, title or ownership to the house when the deceased person dies would go to the named beneficiaries on the transfer on death deed. Okay, in theory, that's what it's there for. But again, it's new. And then again, it doesn't fit in every situation. Let me give you an example, is that, let's say you have 4 kids and you want 4 kids to be the beneficiaries. Well, when you pass away, then all 4 of them become owners of the house. Well, there's no one in charge, right? They're all on equal footing. So let's say one child wants to keep it, another child wants to sell it. You can see where there may be some conflict there. And there's no executor to sort of guide them to what needs to happen. And so there's no executor or trustee. And so it may not necessarily fit with a particular family in a particular situation. And the other thing, probably the most important thing, is with real estate, I always kind of joke around, is that there's the law and then there's the title company. And if you guys have, bought or sold houses, it gets to the title company. That's a big sort of fork in the road of what's going to happen. And so the question is the title company going to issue a title policy on these revocable transfer on death deeds? And the answer is, at least in my experience, maybe. Title companies are getting a little bit more comfortable with them, but I have had situations where a individual has passed away. They had the revocable transfer on death deed. It went to the two kids. They went to sell the house. They got to the title company and they looked at everything that happened, and the title company was requiring for them to go back and probate the will. They weren't going to issue a title policy until the will was probated. And so, all that being said, it is a legal tool available to us, and we can use it in a particular scenario. So,
thank you, Andrew. And I think we've hit the 1 o'clock mark. I do want to extend the webinar a little bit later for anyone that wants to stay on and hear any of the other questions that we have to answer for the next 15 minutes or so. So I'm going to move on. Can you create your own will, and do I need to still retain a lawyer to ensure that the will is legal?
So Carl's on the table, I may be a little biased here. So I am the attorney. So I think, just to answer the question, yes, can you do your own will? For sure. There's resources out there that you can do it yourself. I'll just say this: 95% of issues that I see with wills or with powers of attorney are situations where the person has done it themselves. And so and it's one of those things where you don't necessarily know the questions to ask and sort of guide you through different scenarios. And so an attorney doesn't make it valid. What makes it valid is that you follow the proper statutes. And, with a will, one of the things that has to happen is, it has to be signed by the person. It's called the testator. There has to be witnesses. There has to be a notary. And what I see a lot, is sort of mistakes that are made in the signing of the document. If you haven't done it before, it's a little sort of confusing, a little bit archaic at times. And so we forget the notary, we forget a witness, or maybe one of the things that Texas law requires is that the witnesses have to be present when the person that wrote the will signs. And so I've had situations where people did it themselves and the person signed their will, and then a couple of days later we did the witnesses. Well, that's not a valid will under Texas law. And so there's all these things that can happen, I guess. So my advice at the very least is to, at least get a consult, get some good legal advice. I think it'll be worth it.
Thank you, Andrew. So how do you update a will and living trust that was created in another state and convert it over to Texas law?
Good question. There's a lot of transplants now. There's a lot of people moving to Texas. And so I'm doing a lot of this type of planning these days. I think as a general rule, what needs to happen if you move to a different jurisdiction, if you move from, say, California, Illinois, Oklahoma, and you have your own estate planning done, when you get here, it would be important to have an attorney review what you have. It may be okay to keep what you have in place, but more likely than not, especially with the will, we're going to need to make some updates. And really what we're doing is we are maximizing the benefits under Texas law and Texas probate and estate planning law, so that we can make sure that everything is done correctly and efficiently. And so I think, so high level, have it reviewed by a Texas attorney. There may need some updates. More likely than not, the updates are going to be with the will rather than the trust.
Appreciate that. I'm going to go over some of the questions that we received in the chat function.
Sure.
Someone wanted to know if you have to select an attorney in the area where the incident happened. such as a death in the family? Do you have to probate the will in the area where their father passed?
That's a great question. So when someone passes away and there's a need to do probate, jurisdiction is going to be in the domicile in which the deceased person resided. So if the deceased person resided in Dallas County when they died, then in Dallas County, we're going to need to do the probate proceeding. Now, as far as hiring an attorney, the attorney can be from wherever. You know, I'm licensed to practice in the state of Texas. I can go to any county. Was there 254, I think, as counties, and so I'm legally allowed to do that. Now, each county is a little bit different in how they handle things. Even here in the DFW area, you know, Dallas, Tarrant, and Denton, they all kind of do things a little bit different. Each judges have their own sort of local rules. So if you can, I would say find a local attorney to help you probate that will. So.
Thank you. So another person wanted to know if Texas Legal covers the expenses for a second will. I did answer this in the chat function, but I do want to let everybody know again that Texas Legal plans do cover estate planning as a benefit under your plan. So you are responsible for the premium. So once you're insured, you can meet with an attorney in our participating attorney panel and get that done. Now, if there's any additional costs such as notarization, copying, faxing, that's something that you would have to discuss with the attorney, but in most instances, it should be covered outright. So, and then there is no waiting period from your effective date to get your will done. And we had a few questions about getting the slides out. I do believe that this presentation is going to be recorded so that you can watch at a later time. So someone wanted to know, is right of survivorship the same as payable on death on bank accounts?
Say that. Can you say that one more time? I'm sorry.
Yes. Is the right of survivorship the same as payable on death on bank accounts?
That's a great question. There is a distinction. So if you have a joint account, I think like 99.9% of accounts right now. And so this is banking. So checking, savings. If you have a joint account, those joint accounts are what's called joint account right of survivorship, meaning that when one of the joint owners passes away, the surviving owner becomes 100% owner of the account. And so back in that scenario that we were kind of talking about in the presentation is that, you know, the surviving joint owner is the 100% owner of the account. It doesn't then go down to the beneficiary level. And so then I guess, so what would happen is, okay, if there's the two joint owners, one of them passes away, then we have the surviving owner. When that surviving owner dies, then the beneficiary designations would kick in.
Thank you. So what if the beneficiary passes and it was not changed before they passed?
Great question. So this has been my experience in that situation. Sometimes the financial institution or the life insurance company, they kind of have default rules on what happens in that situation. Typically, if the person predeceased, then the life insurance proceeds or the account would then become a part of that person's estate. And so if it becomes a part of that person's estate, then we're going to need to go to probate court. If you have a will, hopefully, that's going to be a very easy process. And we're going to go through the terms of the will, and who are beneficiaries under the will receive that account or life insurance proceeds. If you don't have a will, we'll go through probate, go down the path of probate in which someone did not have a will. And so that's, again, typically what happens in that scenario is that if the primary beneficiary predeceases and there's no alternate. So sometimes, so there's the primary, and if you have an alternate, then it would just go to the alternate. But if you don't have an alternate, the default is it would go to your estate. And one other thing that just kind of came to my mind, because it's come up recently with a client, is that if you have gone through a divorce, you really want to make sure to update your beneficiary designations as well. You don't want to name an ex-spouse. There are some provisions in the code that may help you. I'll just say this: if it's governed by ERISA, you may not have help as far as not going to the ex-spouse. So key thing, high level, make sure your beneficiaries are updated.
Okay, someone wanted to know, does the age of the children make a difference? I'm assuming. So would the age of a child make a difference?
I'm sorry, you cut out just a little bit. Can you repeat the question?
Yes, so someone was asking if the age of the beneficiary on the will.
So I'm sorry, you broke up. I don't know if it's on my end. Is it the age? Does it depend on the age of the child as far as whether it should go into a trust or not? Was that the question?
A lot of information. It just says the age child make a difference. We can move on.
I'm sorry.
No problem. Let me see. Someone was asking, is there a minimum amount of time you have to keep the plan? Can you cancel at any time? So yes, you can cancel your Texas Legal membership at any time. However, I do want to mention that if you were a member for, let's say, 4 months, you got your estate planning documents, used some of the other benefits, and month 5, you decided to cancel. Well, if you ever needed to re-enroll into Texas Legal at any point, you would be eligible for a $400 re-enrollment fee because you were not a member for at least 1 year. However, if you had your Texas Legal membership for 1 year, used up all the benefits, and at that point you canceled, the $400 reinstatement fee would not be because you were a member for at least a year. So can 401k accounts or be placed in a trust?
They can, but you want to be careful. There are some, not to get too much into the weeds here, there was some changes in the law regarding inherited IRAs and 401ks. And so what we want to do is, yes, you can, but we really want to make sure that in the trust, there are provisions that essentially allow you to extend the amount of time that any tax is going to be owed. And so there really is sort of magic language that needs to be put into a trust in order for us to maximize the income tax deferral on those accounts. And so, yes, you can. I will say this is that, there would need to be a reason to do it, right? So we want to have some type of control. Part of the goals and assets and things that we've ultimately decided, we've decided the trust makes the most sense. Okay, well then we're going to have things flow through the trust. And if you have a 401k, that may be something that needs to go through the trust.
Thank you.
I just wanted to say, and Andrew, thank you so much for your time on this. We are having a little technical difficulty, so that makes it a little bit convenient to be able to cut off at this point. And I know both of you said we will have the opportunity to answer the questions and review the questions. We have them, the webinar recorded, as well as the questions in the chat and the questions and answers. So we'll continue to give you, to the extent that we can, and Andrew can, feedback on your questions. Of course, this is a general seminar, and every situation is a little bit different. So if you have any issues or questions, make sure that you reach out to the appropriate person and that they understand your total situation. It's giving a general answer in a public forum is not necessarily always applicable to your specific situation. So just know that when you go forward and you either contact Andrew or somebody else in Texas Legal. So we really appreciate it. Also, I did see a question from an HHSC employee who said that they're active and they have their Texas legal plan through HHSC. TPEA's plan is independent of whatever these state agencies have. And so I don't have the answer to that, but Anna may know the answer to that question. But as a TPEA member, as long as you are a TPEA member, you will get the TPEA discount, whether you're an active employee or a retired employee.
Thank you, Anne. And just to add to that, the TPEA plan is a little bit different. So there is an additional benefit that's not available to the state agencies. So if you feel that you may need to use this benefit in the future, I would suggest to convert, but you're more than welcome to stay under the HHSC or any other state agency plan that you may be under.
And what is the benefit difference?
Under agencies, but is covered with TPEA.
You broke up again. I'm sorry.
It's for employment related matters. That's an
Okay.
additional benefit that's offered.
Okay. All right. Well, we appreciate it. Thank you, everybody, for tuning in. Thank you for your service, whether it's current state service or you had state service in the past. And I will tell you that planning your estate is very, very important. Getting these documents in place is very important. I've had to be in probate for several of my elderly relatives, and the more it's laid out, and the more information that is available and documents are correctly signed, the easier it is not only to deal with the estate, but the other beneficiaries. So we'll see you soon. Thank you.
Thank you.